Okay, that wasn't too bad, although I imagine there were others who were probably experiencing difficulties in trying to rejoin the meeting. Because I only see 9, we lost about 7 of you. So others are starting to join now. Now, before we move over to question number 3, would there be any question that you might want to ask? Comments? Anything you wanted to clarify? So we're good? Okay, so I don't think we could wait for the others. It seems it's taking a bit longer for others to join us. We could probably just proceed. Okay, so discussion question 3. If there are no questions, we'll proceed to discussion question 3. So no questions? Okay, so discussion question 3. The Commonwealth Parliament passed the Dietary Supplements Regulatory Act Commonwealth in order to regulate the production, distribution, sale, and marketing of dietary supplements, many of which had exaggerated claims and no proven efficacy. XYZ Enterprises was penalized under the Act for failing to meet regulatory standards. However, the activities, operations, and products of XYZ Enterprises were legally compliant under New South Wales legislation. XYZ Enterprises seeks to challenge the Commonwealth law on the ground that the Commonwealth Parliament cannot legislate in relation to intrastate trade and commerce. So in other words, the trading of XYZ Enterprises is solely within New South Wales. And XYZ Enterprises also argues that the law cannot apply to it since it does not engage in interstate trade or commerce, and that all its production, distribution, sale, and marketing is limited to New South Wales, which is a circumstance that it is able to prove. Advise XYZ Enterprises on whether its legal challenge is likely to prosper. Volunteers? Volunteers. Any volunteers? So, any volunteers? Who else is actually here but hasn't said anything so far? Can I get one?
Manjo, but unfortunately I can't find exactly what would back this one up. I just remember reading in the textbook that because this one involves solely intrastate trade and there seems to be no... there could be the potential, I suppose, for them to export to other states, but at this stage they're an interstate business. If it's solely interstate, then it's not within the Commonwealth's scope of power.
Okay, so we have the view of Robert here that the law is in fact unconstitutional because it ends up regulating trading within a specific state. Okay. Any comments to that? Any supporting view or any dissent? From Ken, does the Commonwealth Act apply? Ken, would you like to explain your question there? What is meant by that? So, New South Wales legislation. Okay. I still can't get what it is that you're actually trying to say here. Ken, would you like to pick up the mic? Okay. So, does the Commonwealth legislation override the state legislation? Okay. I wanted someone to respond to what Robert had said, that the law is actually unconstitutional because it attempts to regulate intrastate trading within New South Wales alone. And according to Robert, therefore, if you follow section 51.1, that particular head of power cannot apply because it only relates to interstate trading or trading with other countries, but not to intrastate or to in-state trading, which appears to be the case in this tutorial question that we have.
Manjo, could I throw in, maybe we're looking at the wrong head of power. We could also look under 23A, where we can regulate pharmaceutical, medical, and
We're looking at
services.
which section?
51,
Yes.
subsection 23A, which relates to pharmaceutical, medical, dental. I think that'd be a pretty easy head of power that you could put it under rather than trade.
Okay. Okay, so
which would be
that's one way of doing it, possibly. But how about in relation to the point made by Robert here, that this seeks to regulate intrastate or in-state trading? Do we have any response to that? Comments?
Would you say that the effect it has on the intrastate trade is merely incidental?
Mm-hmm.
Because the regulation does not expressly only apply to intrastate trade. It's actually meant for trade, international, interstate, and so on and so forth. It's just that in his case, he only does intrastate trade. So the regulation is not singling, discriminative, burdensome, or protectionist, and therefore it should be valid. And like I did mention that under strictness previously in Huddard, Parker, and Moorhead, they on the old way of interpretation, they actually held that purely intrastate trade was beyond the power of Commonwealth, but they reversed that in Strickland and Rockler concrete pipes. So it should be valid, and it would apply to XYZ.
Very good, B. So the fact that it ends up regulating in-state trade or commerce is merely incidental, because this legislation does in fact seek to regulate trading between states or even with other countries. It has the effect of obviously of regulating as well exports pertaining to dietary supplements. So the fact that XYZ Enterprises may have been caught in that legislation, even though XYZ Enterprises trades solely within New South Wales, is really not important. What is important, though, is that this is a legislation that could be justified under Section 51.1 of the Australian Commonwealth Constitution. Okay, and then we have the same argument that in the event that there is an inconsistency between state legislation, such as the New South Wales legislation, and a Commonwealth legislation, it will always be the Commonwealth legislation under Section 109 of the Constitution that will prevail. Okay, so we're good. Questions? Thank you, B. It was very good. Comments? None? Okay, let's move on. So, I just wish to emphasize again that as far as constitutional law is concerned, as far as being a lawyer is concerned, you need to be able to make an argument. You need to argue it, argue your position. So it's insufficient for you to just cite a provision, or it's even insufficient for you to just cite a case. You need to be able to clearly draw a link or a connection between the law or the principle and the facts of the case. So that's where the application comes in. It is in the application that you're actually making an argument, where you're trying to persuade perhaps a judge, or at least persuade your marker in the context of an assessment. But if all you do is to just cite a constitutional provision or cite a jurisprudence or cite a high court decision, that will be insufficient, because how is a provision or a case meant to support your conclusion if there has been no argument that is coming from you, especially in the context of Section 51, which is quite broad and is difficult to apply without resorting to the engineer's case, for example. Okay, so moving on to the final question, discussion question 4. In order to spur the tourism industry in South Australia, the Commonwealth Parliament passed the Theme Parks Special Incentives Act Commonwealth, which provides special incentives, financial grants, and tax breaks to businesses that establish and operate theme parks in South Australia. As a result, theme park operators in South Australia have attracted many local and international tourists through strong advertising and marketing and better deals, including lower theme park entrance fees. ABC Proprietary Limited, a theme park operator in Queensland, argues that the Commonwealth law promotes anti-competitive activity and is protectionist after seeing a huge decline in its revenues as a result of competition from South Australian theme parks. It now seeks to challenge the Commonwealth law. Advise ABC Proprietary Limited on whether its legal challenge is likely to prosper. Volunteers? I see a lot of other students who are actually in this session, but so far aren't inclined to pick up the mic. Can I entice some of the others to pick up the mic?
Merely because they are looking to improve the economic gain of one particular area does not mean that it's at the cost of another. So they do these things all the time with regard to even like whereabouts they're going to put the defence bases, where they're going to do this, where they're going to do that.
Yes.
It's not on the basis of that it's playing favourites with the state. It's part of their business to ensure that there is a benefit and an improvement across the country as a whole. And this will then take turn in being focused in different areas at a time. To say that you're playing favourites merely because you're missing out, it's not saying that the government is discriminating against you in any way, shape or form.
Very good. I saw Karen. Thank you, Carl. I saw Karen, I think, raising her hand. Karen. Was that Karen? Yeah, Karen. Yes, Karen, you may have to unmute yourself.
Can you hear me now?
I could, yes. Go ahead.
Sorry about that. I looked at this one on the basis of the Cole-Whitfield case, and what came out of that was what was referred to as the Cole-Whitfield test.
Yes.
Namely, is a law a burden on trade, discriminatory and protectionist? And it needed to have all three of those components to then be an offence, so to speak, against Section 92 of the Constitution. And what I thought was, whilst it certainly was a burden on trade and was discriminatory in that it helped South Australia but didn't help anyone else, it wasn't protectionist as such, because it wasn't acting to protect the theme park industry in South Australia to the exclusion. It was just there to help prop it up, so to speak. And that because the Act didn't meet all three of those things, therefore a legal challenge wasn't likely to prosper.
Very good. Any dissenting opinion? Is there a dissent?
Yep, I dissent.
Who's that? Go ahead.
Yep. Yep. Because of Section 99 of the Constitution.
Go ahead, yes.
And where it clearly states the Commonwealth shall not, by any law or regulation of trade, commerce or revenue, give preference to one state or any part thereof over another state or any part thereof. And it clearly says in the first part of the question that the Commonwealth Parliament passed a particular act which provides special incentives, financial grants and tax breaks to businesses that establish and operate theme parks in South Australia.
Well done, Janet. So, actually, Section 51, or even the power of the Commonwealth Parliament to legislate, is subject to Section 99. Because remember, if you look at Section 51, it says subject to the Constitution. So whatever the Commonwealth Parliament legislates on it is always subject to the other parts of the Constitution. And Section 99 expressly provides that the Commonwealth cannot give a preference to a state in relation to trade, commerce, or revenue. Okay, so have a look at that. So thank you for pointing that out, Janet. Now the question I have, who's that?
Robert.
Robert, yes.
Play slight devil's advocate here and say that it doesn't actually discriminate against operators who you don't have to be an operator from South Australia. The Queensland operators could build and operate a park in South Australia, so it doesn't necessarily discriminate against other state operators.
Okay. But that raises the question here, Robert, is the issue here really about discrimination, or is the issue here about the Commonwealth not being able to give a preference under Section 99 of the Australian Commonwealth Constitution? So as pointed out by B, I think this is what she's saying, it may not discriminate, but it does give a preference. And when you think about it, giving a preference does discriminate. But it's more explicit as far as Section 99 is concerned, because the Commonwealth Parliament is not permitted to give a preference in relation to regulation of trade, commerce, or revenue. So in other words, Section 99 trumps the issue of non-discrimination, because the Commonwealth Parliament is not permitted to give a preference in relation to regulations of trade, commerce, or revenue. Okay, but I have a question, because actually under Section 96, the Constitution does provide that the Commonwealth Parliament has the power to grant financial assistance to any state on such terms and conditions as it thinks fit. So we are confronted with another provision, Section 96 of the Constitution, that actually gives the Commonwealth Parliament the power to provide financial assistance to states. And that provision, the Commonwealth Constitution provision, is still in place. So,
what sort of financial assistance are they talking about, though? Are they talking about direct financial assistance in the terms of money for roads or something like that, as opposed to preference in respect of trade?
Yeah, the provision is quite broad, and I would imagine that a financial grant is captured under the concept of a financial assistance. So Brad was actually pointing out, does it not say 10 years? And the answer, as pointed out by Karen, until the Parliament otherwise provides. So the Constitution does continue to provide the Commonwealth Parliament the power to grant financial assistance to states under Section 96 until the Parliament otherwise provides. So it is not a spent constitutional provision. It remains alive. And that is, in fact, what the Commonwealth Parliament has been using every time it grants financial assistance to states, whether in regard to roads, education, or health. Apart from the fact there is
Manjo, wouldn't there be a difference between providing assistance to the state government and providing benefit or preference to businesses that operate within the state? There'd be two different entities that are actually providing it to.
What do you think? Are they the same or not?
No, well, it wouldn't be. It wouldn't be, because the entity, the argument could well be that the entity in South Australia, because of the business that they're in, the entity in South Australia could well be a wholly owned subsidiary, as is, say, the same business that's complaining that is operating within Queensland. Because they themselves, the businesses, say, for instance, that are here in Queensland, are owned by the, Macquarie Bank and Village Roadshow and all that sort of thing. So they're not actually specific just to here. It's really just a matter of where they conduct their business. Right. But then when they're providing assistance to the state with the capital S, so it'll be the state being the state government.
Yes. So
as opposed to a business operating within the state.
That's right. So I'd like to go back to the point, the very valid point that you were making, as to whether or not there is actually a distinction that should be made between financial assistance to the state directly and financial assistance to the state indirectly, in the sense that there is a financial assistance to certain industries or businesses within the state that indirectly then assists the states. Is there a distinction? Can we make that distinction?
If the money was granted by the Commonwealth to the state, and the state then decided to appropriate to such a decision as per the first part of that scenario, that's different, because it's the state looking after the welfare of the state and the economic side of it. However, that means it's the state doing that, not the Commonwealth doing that for certain sectors of that state.
Yes, very good. So going back to that question that has been raised by Carl, which is really valid, would it make a difference if the financial assistance is to the to businesses or industries and not to the states themselves? So in other words, are we saying that it is not permissible for the Commonwealth Parliament to provide financial assistance to entities or to industries or businesses within the states, because that is not covered under Section 96? And if the Commonwealth Parliament were to provide financial assistance to industries directly, then in that case, that may amount to giving a preference to a state or any part thereof. That seems to be the argument there. What do you think? So from Kent, they have done it for the car industry. And when they did that, Kent, what exactly happened? Was it valid or not?
Yeah, but when they did it for the car industry, it was both in Victoria and South Australia.
Okay. So in that case, could the Commonwealth Parliament justify its power to give financial assistance directly to the certain industries, such as the car industry, on the basis of Section 96, so that they don't have to deal with the issue of Section 99 concerning the inability of the Commonwealth Parliament to give a preference to states or any part thereof? Okay, so from B, what do you think?
With regard to that, they could do anything, and as long as nobody was really bringing any action against them with regard to it,
yes,
to force the point.
Yes.
I mean, it's not a matter of the High Court's not going to be a full-time referee and be advocating on every single thing that the government does. It's only really with regard to somebody saying, well, hang on, I want to bring an action against this because of its, on the grounds of its constitutionality.
Very good. But so we do have a situation, a historical precedent where the Commonwealth Parliament gave a subsidy to the car industry directly. And we could assume that the Commonwealth Parliament did this on the basis of Section 96. As pointed out by Carl, the fact that no one questioned the constitutionality of that law we shouldn't be reading too much into that incident, because the fact that no one questioned the legislation doesn't mean that the law is constitutional in the first place. Is that the way others would see it? The fact that no one questioned the constitutionality of the law shouldn't be read as an acknowledgement that the law is valid in the first place. Or could an argument actually be made that the reason why no one questioned it in the first place was because they had an understanding that the law was going to be valid in the first place, and therefore it was going to be inefficacious or futile to bring it to the High Court to question its constitutionality?
Could I throw in, Manjo? There seems to be, I just did some quick research. I hadn't read the case. It's the flour tax case, which is cited as being authority that Section 99 and 51 don't apply to grants made under 96. That was tested back in the 40s. Okay. And so what in relation to the question that was raised here, should the ability of the Commonwealth Parliament to grant financial assistance to states extend to its ability to directly grant financial assistance to industries within states themselves? Meaning, would that be caught by Section 99 or not? Because if it's not caught by Section 99, in other words, if our interpretation is that the Commonwealth Parliament cannot directly grant financial assistance to industries within a state, then we have to deal with Section 99 of the Constitution, where the Commonwealth Parliament cannot give preference to a state or any part of a state. What's the answer?
Well, the state could argue preference, as they do, like as is recently the discussions with regard to GST revenues and dispersion and the like. People say that, well, hang on, this is some of the states claim that it's unfair with regards to what they're getting, and it is still the federal government's role with regards to funding allocations and the like amongst the states. Everybody needs to agree on the GST, but the federal government still does have to make qualitative decisions with regard to how much grants or funding and allocations it does give to the state governments themselves. Any one of the state governments can, as they do all the time in the COAG meetings, complain about favouritism. But it's just part and parcel of the game that they all play. Okay. So if you ask me, I'm not aware of a High Court decision on the subject. If you ask me, we've got 10 minutes. Section 96 should actually enable the Commonwealth Parliament to grant financial assistance, not just to the state, but to any specific business or industry within the state. Because, hang on, Janet. In other words, if the financial assistance is actually given directly to an entity or an industry within the state, it has the effect of benefiting the state itself. And that is actually the reason, I would imagine, why no one has bothered to bring it up to the High Court to question the constitutionality of Commonwealth legislation that seeks to benefit specific industries of a state. Janet, you wanted to say something?
I was just going to say that I felt it fit under Section 51.
What was it?
I thought that what you have just said fits well under Section 51(1).
Okay, but if you go back to Section 51(1), what we need to remember is that Section 51 has to be subject to the Constitution, to other provisions of the Constitution. Okay, so now the answer here is that I would actually advise the ABC Proprietary Limited to challenge the constitutionality of the law, mainly because what we will see is that the legislation involves granting special incentives and even tax breaks, not just financial grants. So perhaps, although it might be argued that the Commonwealth Parliament can provide a financial grant, not just to the states, but to industries within the state, but for it to provide special incentives and tax breaks to a state would actually therefore be giving a preference to a state or to a part of the state which would contravene Section 99 of the Commonwealth Constitution. Okay, so although it could be argued that the grant of financial, the giving of a financial grant may be captured under Section 96, which in a sense empowers the Commonwealth Parliament to grant financial assistance to states or a part of the state, still the giving of special incentives and tax breaks would be contrary to Section 99, which prohibits the Commonwealth Parliament from giving preference to a state or to a part of the state. Do I see Nicholas raising his hand? No? Oh, whose hand is this? Sorry.
Oh, sorry.
You're good.
Type that down.
Okay.
That was all.
Thank you. Okay. So, any questions, comments? We're clear? So, if there's anything that we should take note here, remember always the need, number one, for the Commonwealth Parliament to be able to cite a head of power under Section 51 or the Constitution. Two, we need to remember the engineer's case, which provides for the expansionary application of Section 51. Thirdly, what we need to remember is that the power of the Commonwealth Constitution under Section 51 is subject to other provisions of the Commonwealth Constitution, such as Section 92, Section 99, and Section 96. And fourthly, what's equally important is that we need to be able to make an argument every time you provide an answer. It will be insufficient for you to just cite a constitutional provision or a specific high court case. Okay, any questions before we end tonight's tutorial?
Yes, Manjo, I just wanted to try and sum up what you just said.
Yes.
I got a bit lost on the way. So
Yes.
the Commonwealth can provide financial assistance under Section 96 as long as in the process of providing this assistance, it doesn't give preference to any state under Section 99. So as long as what they're doing don't cause a conflict, is it, in the provision?
No, not exactly. That's not the way we should read it, no. What it means is that the Commonwealth Parliament can provide financial assistance under Section 96 of the Constitution. But what it means because remember, every time you give a financial assistance, that actually is giving preference to a state. So you can't give financial assistance without giving a preference to a state. That's part and parcel of giving financial assistance. What Section 99 prohibits, however, is actually giving preference, not in the form of financial assistance, because that's an exception under Section 96. What is prohibited under Section 99, however, is giving preference to a state in relation to regulation of trade, commerce, or revenue. So there is an exception. If the preference is in relation to financial assistance, that is fine. But if the preference is in relation to regulation of trade, commerce, or revenue, that is what is not allowed by Section 99. So in relation to the expansionary case, that is the engineer's case, where for as long as the Commonwealth Parliament can actually base its legislation on a specific head of power, for as long as there is an incidental link even to a head of power, such as, it legislates on agriculture, it legislates on education, and then hinges that legislation either on Section 51(1) on trade and commerce, or on Section 51, subsection 20, concerning trading or financial corporation. So for as long as there is a connection. It doesn't even have to be strong. Under the expansionary doctrine espoused in the engineer's case, that is permissible. Because, as the High Court said, it was unwilling to read a limitation on the power of the Commonwealth Parliament to legislate on the notion that all the other residual powers necessarily belong only to the state parliaments. So in the absence of an explicit limitation in the Commonwealth Constitution, the High Court said that it was unwilling to consider an implied limitation on the power of the Commonwealth Parliament to legislate. So that is according to the engineer's case. Okay, so any other questions? None? Okay, so thank you everyone. And I hope to see you again next week for the next tutorial on week 9. Thank you and good night. Bye.